Can I ask you a question?
Yes, absolutely.
So you mentioned just now a common issue that you've encountered with premise liability cases is the notice. Can you elaborate a little bit more on that?
Absolutely. Not too many attorneys understand this. Premises liability cases are good cases, although the liability element is usually at issue because there's that argument of not having sufficient notice. But premises cases, you're usually dealing with a corporation, a store, and they have large general liability insurance policies. So that's always an advantage. There's insurance there. But in order to find someone liable, there must be a duty, a legal duty to act, prevent, to make safe. If there's no notice placed on someone and they don't have a duty to do something or not do something, then there's no legal liability. And in premises cases, that is always the key issue. Was there notice? So a lot of times in your pleadings, if you're drafting a complaint, for instance, take a slip and fall case in a supermarket, a common premises liability cases, you don't want to keep it specific to the puddle in the supermarket, all right? Because that's too easy for the defendant to say, oh, we didn't have notice of that small puddle. What you want to do instead is frame it in the form of operational failures. It's the bigger picture. Every premises case, every corporation has operation procedures, and somewhere down the line, there was a failure. That is the breach, not the fact that there was a specific small little puddle there. That's too easy for them to escape and say, oh, we didn't know. We didn't have notice of that. But if you can frame the case in the form of the bigger picture, an operational failure of the corporation, whether that is years before, a week before, a day before, or even hours before, somewhere down the line, there was a failure. Does that make sense?
I love that answer. Very good information. Thank you.
Also, another tip is the employer, the corporation, is responsible for the acts of the employee. So, for instance, one case that I had was the employee was dragging the trash bag out of the supermarket and there was a trail of slippery substance coming from the trash bag. Now, obviously, the employer didn't do that. It was one of their employees, but the employee created the condition. And if the employee creates the condition, it's implied that there was notice on the employer. That's by case law. It's good case law. Conditions that were created by the employee, it creates constructive notice on the defendant corporation. There's actual notice and constructive notice. Both satisfy the element of notice. And you always want to argue the actual notice is stronger, that operational failure, the bigger picture. You don't want to get it confined into small, specific facts. It's easy for the defense to argue that they didn't know it, wasn't possible for them to figure it out. But if there was a breach, a failure somewhere down their operational systems, then that's a better argument. And then if you can find out if the condition was created by one of their employees, then it's constructive notice, and that satisfies the element of notice. And not too many attorneys really know how to argue the element of notice, and they lose cases on that element.
I agree with that by experience. I will say that's the first time I've heard that in 10 years. So I've worked with a few attorneys. So.
And I'm telling you this because I know, because you told earlier that you draft pleadings. You're drafting the complaint. So you got to know how to draft the complaints properly. When you're drafting the complaints and you're alleging, oh, there was a puddle, the plaintiff slipped on the puddle, you're going to lose the case because it's too narrowly confined. You need to go bigger. It needs bigger, larger liability, operational failure. All right, don't just say, oh, there was a puddle. There's so many things in those procedures that went wrong. All right, so you got to, in your pleading, you got to be careful in your pleading stage. So always frame the case in a system failure.